And thank you for joining us here on PM Express. It's a Monday, and the Supreme Court is subject of some further scrutiny again. And there are two issues that has been agitating people's minds. You may have seen this raging controversy since that landmark Supreme Court verdict that says the Deputy Speaker of Parliament can vote whilst he's presiding. Well, now we understand that the man who first took this matter to the Supreme Court has filed for a review of that decision. We'll talk about that mainly. And then you've heard the National Security Minister also speaking to judges, make some pronouncements that in itself is raising some questions. I mean, his comments has largely been criticized by members of his own party and his government, indeed. We've heard today from the chairman of the NPP legal team suggest that Kandapa's comments that when judgment from the courts appear to be skewed towards them, as in the ruling party or the government, it gives the impression of bias about the courts and the judicial system, and that has been criticized. Later on, I'll ask my guests what they make of that comment by the National Security Minister. We're speaking in the context of national security, by the way. But let's focus for a second on this very important action that the Justice Abdullahi had decided to embark on at the Supreme Court on the back of a unanimous decision. That's a hurdle he has to cross. And he's filed this case asking for a review of the Supreme Court decision on the basis of miscarriage of justice, he argues. And then he lays out his case fundamentally. And the Supreme Court ruling on the 9th of March made three fundamental, profound judgments. Well-reasoned, if you read it. Well-reasoned, thorough, very well-researched. Many were convinced by it at the time, including myself, I must admit. But Justice Abdullahi believes fundamentally that there's been a miscarriage of justice and he wants to challenge that. We'll come to his basis very shortly. But these are the three decisions that the Supreme Court reached. One, that the Deputy Speaker could himself vote for purposes of quorum, can vote and maintains his original vote. Also, that the Order 1093 of the standing orders, they struck that out because it is inconsistent with the Constitution, because it takes away the acting Speaker's powers of voting, right? And then approval of the budget and economic policy of the 2022 was, the Supreme Court held that was valid because, of course, if they held that the Speaker, the Deputy Speaker, can indeed vote while presiding, and he did so in approving the budget, then of course that decision stood. So three decisions, and Justice Abdullahi has gone to the Supreme Court challenging this. Now, these are the grounds that he's gone to the Supreme Court with. One, that the exceptional circumstances which have resulted in miscarriage of justice. These are the basis. You can't go to court, right? You can't go to court to challenge a decision of the Supreme Court, especially in the case where like this, which is very unanimous, unless you can prove some of these ingredients. One of the first ingredients is that there must be exceptional circumstances which have resulted in a miscarriage of justice. That is why I stated earlier that Justice Abdullahi believes there has been this miscarriage of justice. And then second, ground that you must have to prove in court that you've discovered some new and important matter or evidence, which, after the exercise of due diligence, was not within the applicant's knowledge or could not have been produced by him at the time when the decision was given. He says he's found something like this that he's going to bring before the court. Now, according to Justice Abdullahi, and this is some of the key things he's bringing out, the ordinary bench failed to consider legislative antecedents when he held that the Deputy Speaker has an original vote. And he cites this clause here. This is what the Supreme Court said, that it's our humble submission that the ordinary bench of the court overlooked on considerations of legislative antecedents and then to Constitution. This is his point that he emphasizes, and he cites the relevant clauses to back his argument. This clause says any other person, including the Deputy Speaker, shall, when presiding in the Assembly, have an original vote but no casting vote. He's pointing this out, and he will have to make this point before the court. Again, he makes the point the Speaker shall have neither an original nor a casting vote, but any other person presiding, including a Deputy Speaker, shall have an original vote but no casting vote. He's citing constitutional and legal provisions to back his point here, which is what is before the court. We'll get him to explain fundamentally what all these mean to his case and the potential success of his case very shortly. It's clear from Article 80 of the Constitution, 82 of the 92 Constitution, an article, he mentions a lot of these articles, that a person presiding in Parliament is expressly excluded when determining a quorum of Parliament. So he's going back to make these profound cases. And if you see the clauses in question, he will have to resort to the fundamental 104, which is one of the most contested issues or contested provisions of the Constitution recently. It's going to be front and center again when this goes to trial for a review at the Supreme Court. He's going to join me very shortly for a conversation, and other legal minds also. But I want to also throw in at the end the comment by the National Security Minister, which ties into all this, because he had said that when the court appears to be ruling consistently in the favor of the government or the power of the ruling party, then it creates a certain perception of bias. I wonder what my guests say about that. When we return from the break, we're going to get into that conversation. Stay with me.